All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Court officer, please call the case.
Good morning, Mr. President, Your Honors. Situation in the Central African Republic 2 in the case of a prosecutor versus Affaire Yekatom and Ngai, ssona, case reference ICC 0114-0118, and for the record, we are in open session.
Thank you. I ask for the appearance of the parties. Mr. van der Poel first.
Monsieur le Président, Monsieur les juges, Madame les juges.
Pardon, monsieur.
Okay.
Of course, yeah.
Je suis pas habitué à être vu, ça se comprend. Le bureau du procureur est représenté aujourd'hui par moi-même, Mandiaïan, procureur adjoint. Et à mes côtés, vous avez Monsieur Van der Poel, qui est la figure la plus familière, bien entendu, substitut du procureur principal. Madame Olivia Struven, qui est substitut du procureur, Monsieur Lucio Garcia derrière moi, également substitut, Madame Maria Berden-Nikova, substitut également, Madame Sylvie Vakchom, associée du substitut du procureur, Madame Manochitra Prataban, également substitut associé, Monsieur Yassine Mosfa, qui est le gestionnaire de notre dossier, et enfin, Madame Laila Axios, également. Je vous remercie.
Yeah, thank you so much. And now we turn to the representatives of the victims.
Je vous remercie, Monsieur le Président, Madame, Messieurs les juges. L'équipe des représentants légaux des victimes des autres crimes est composée de Paulina Masida, Orchlon Narantsetse, Enrique Carnero Orullo, Alexis Larivière, Evelyne Ombeni et moi-même, Marie-Edith Douzima. Je vous remercie.
Thank you. And the representatives of the former child soldiers.
Good morning, Mr. President. Good morning, Your Honors. The former child soldiers are represented today by Amina Merouche and myself, Dmitry Supron. Thank you.
Thank you. I turn to the defense. First, the defense of Mr. Yekatom.
Good morning, Mr. President. Good morning, Your Honors. Good morning, everyone. Mr. Yekatom is present in the courtroom today, and he's represented by Ms. Anta Guissé, Ms. Sarah Bafadel, Mr. Guillaume Suzuki, Mr. Florent Pages-Granier, Ms. Sabrine Bessa, Ms. Yusra Lamkadam, Ms. Alexandra Baer, Ms. Léa Benoit, and myself, Mylène Dimitri.
Thank you very much. For the defense of Mr. Ngai, ssona, Mr. Knoops, please.
Good morning, Mr. President, Your Honors. Good morning. First of all, our team wishes the court, especially the bench, everyone in the courtroom, best wishes for the new year and a prosperous judicial new year. I think that's important to say first. We are represented today, Mr. President, by Ms. Marilyn Proux, Sarah Pedroso, Madame Lou Crignon, second bench, Matthias Goffet, Despina Eleftherio, and on my left side, Alexander Disdavi, Melissa Beaulieu, and Chiara Giudici. And Mr. Gassona is on the third row. Thank you.
Thank you, Mr. Knoops. Now the first to make the submissions is the prosecution. I give you the floor.
Encore merci, Monsieur le Président, Madame la juge, Messieurs les juges, le procureur Van der Poel présentera nos soumissions pour le compte du bureau du procureur. Et je ne voudrais pas rater cette occasion pour venir au nom du procureur principal, mais également au nom de tout le bureau, pour vous remercier d'abord à vous, Monsieur le Président, Madame le juge, Messieurs les juges, pour votre patience. Et ensuite, pour associer à ces remerciements, en fait, tous les protagonistes de ce procès, qui quand même, dans quelques semaines, en fait, aura pris beaucoup de votre temps, aura duré quasiment 4 ans. Donc cela veut dire que ça a été un long processus, y compris à travers la période extrêmement difficile et à laquelle personne n'était préparé, c'est-à-dire la période de la Covid. Donc, pour avoir été aussi imaginatif et pour avoir quand même pris toute votre imagination pour conduire cette procédure à travers toute cette période, je crois qu'il est bon que notre bureau vienne vous exprimer en fait toute sa reconnaissance. Mais bien entendu, j'aimerais aussi prendre juste quelques mots avant de laisser la parole à M. Kweku Van der Poel, en fait, pour vous rappeler ce que vous savez déjà, au regard en fait de ce qu'a traversé toute la communauté centrafricaine à travers ce dossier. Très souvent, quand on parle de ces crimes de masse, il y a un certain risque. Le risque, c'est lequel? D'abord, c'est vrai que tout le monde est ébahi, tout le monde est affecté par la gravité, par l'énormité des crimes. Mais malheureusement, quand nous sommes dans ce genre de salle aseptisée, finalement, en fait, le risque est que tout semble se réduire simplement à du chiffre, à des nombres. On parle de victimes et malheureusement, très souvent, on ne peut même plus mettre de nom sur chaque victime. Et le risque, c'est que si on y prend garde, on peut rendre une justice aseptisée. Parce que quand même, bon, ça devient un exercice extrêmement technique. Mais j'avais voulu profiter de cette présence ici avant de donner la parole à M. Kweku. Vous rappelez cela. Je sais que vous le savez déjà, mais un rappel n'est jamais de trop. Ça va faire peut-être bientôt 3 ans que je suis ici, mais l'un des pays de situation que j'ai le plus visité, c'est la Centrafrique. J'y ai été à plusieurs reprises et au cours de toutes ces visites, j'ai eu le privilège, je dois même dire le redoutable privilège d'avoir rencontré les victimes. J'ai vu des communautés extrêmement affectées. On ne parle pas seulement des morts, mais même parmi les survivants, on voit à quel point elles ont été affectées. Et ce sont pour la plupart des gens qui ont perdu des choses que même vous les juges, malgré toute votre bonne volonté, vous ne pourrez plus jamais leur redonner. Mais nous sommes dans un système de justice également restaurative et restributive, et donc donner une peine en fait, qui correspond à l'ampleur des dommages causés fait partie de ce processus judiciaire. C'est vraiment en quelques mots ce que je voulais vous rappeler avant de donner la parole à mon collègue Kweku Van der Poel. Rappelez-vous toutes ces victimes. Rappelez-vous ces morts, mais rappelez-vous aussi ces survivants. Je me souviens dès les premiers jours quand j'étais ici, en me familiarisant avec le dossier, quand j'ai regardé même la composition statistique en fait, de la Centrafrique, y compris de Bangui, a complètement changé à travers simplement ce qui s'est passé. Et vraiment, c'est ça que je voudrais vous rappeler avant de donner la parole à mon collègue. Merci de votre attention.
Thank you, Mr. Van der Poel.
Good morning, Mr. President. Good morning, Your Honors. Good morning, everyone. Thank you, Mr. Deputy. It's my privilege to appear before this chamber once again in this matter on behalf of the Office of the Prosecutor and my team. Let me just say that we don't expect to use the full 3 hours that we've been allotted, but you know how that goes, Mr. President, so I'll do my best to finish up a little bit early. Our written submissions, as you know, address several issues before the chamber, and I hope that we don't have to revisit too many of them. We have carefully evaluated the respective defense team's written submissions. Some of the arguments that are raised there we anticipated in several filings during the course of the trial, and also addressed to the extent possible in our limited written submissions. So we don't believe that a substantial amount of time is necessary in order to develop them. However, with that said, we do intend to address some of the salient issues underpinning our specific recommendations in this case, and which respond to the defense's characterization of the case as concerns the accused's participation and intent, and other factors listed in Rule 145. This is the first time at the court in which sentencing submissions will have been made and argued before an Article 74 judgment has been issued. Our submissions, therefore, proceed on the basis that the defendants are convicted as charged, an outcome that we firmly believe the vast amount of evidence in this case not only substantiates but compels. Let me just turn briefly to the prosecution's sentencing recommendations. As indicated in our 13 December written submissions, the prosecution considers that upon conviction of the charged crimes, the defendants Affaire Yekatom and Patrice-Edouard Ngai should receive joint sentences of not less than 22 years and not less than 20 years, respectively. These terms of imprisonment fairly and appropriately reflect the gravity of the crimes charged, the scope and the breadth of victimization, the attendant circumstances, including aggravation, and the absence of any compelling mitigating circumstances pursuant to Articles 77 and 78 and Rule 145. They will moreover ensure that the objectives of the sentencing within the contemplation of the statutory framework are achieved, particularly retribution and deterrence. The crimes for which these defendants bear responsibility are extremely grave. They're shocking not only in their nature, but also in the manner in which they were systematically perpetrated by the Antibalaka. These crimes were inflicted on vulnerable persons, insular, defenseless communities, and innocent civilians, including children. Nothing of such conduct or participating in it to any extent, regardless of the motive, is excusable. Nothing of it is justifiable. The nature of the crimes to which the defendants contributed are set out in the confirmation decision. We believe they have been proved beyond any doubt in this case. As you know, in some instances, the charged conduct is classified as both crimes against humanity and war crimes. Specifically, murder, forcible transfer and deportation, displacement, torture, and rape. The conduct classified as crimes against humanity only, particularly, are severe deprivation of physical liberty, persecution, and other inhumane acts. And the conduct charged as war crimes only are cruel treatment, directing attacks against the civilian population, conscription, enlistment, and use of children under the age of 15 years to participate actively in hostilities, directing attacks against a building dedicated to religion, pillaging, and the destruction of the adversary's property. Mr. Yekatom is responsible for 21 counts. Mr. Ngai is responsible for 31 counts. the breadth and depth of their respective participation in the crimes is substantial, to say the least. In many domestic jurisdictions, criminal responsibility for a single murder could easily justify the imposition of a life imprisonment sentence, if not a very lengthy one. Participation in the commission of such an offense under the statute in any form is at least as grave. Their inclusion in the statute means by definition that the conduct comprises the most serious crimes of international concern. I can't emphasize that enough. We are here precisely because the nature and, importantly, the gravity of the offenses charged and in which the accused participated is immense. As Article 1 of the statute contemplates, the purpose and scope of the court's establishment is to exercise jurisdiction over persons for the most serious crimes of international concern. While the several crimes I've just outlined are self-evidently serious, imposing a sentence of conviction for any one crime must reflect the degree of seriousness for which this court was established. The seriousness which demands that the defendants meaningfully be held to account for their participation, involvement in the crimes. The seriousness which understands that it is their individual conduct that is the measure of their culpable participation. And the seriousness which impels the prosecution to demand that this court of last resort deliver justice for the thousands of victims of the anti-Balakist crimes to which these defendants criminally contributed. Simply put, serious crimes demand serious punishment. Our recommendations are consistent with the general principle that a sentence be proportionate to the gravity of the offenses committed, and that it fully reflects the convicted person's degree of participation and or culpability in the commission of the offense. The different recommendations as between the two defendants are justified and appropriate in the circumstances of this case. Mr. Yekatom was more hands-on in the commission of the crimes within the context of his anti-Balaka group as its senior-most figure and commander. Ultimately, he played an essential role in his group's commission of the charged crimes. Mr. Ngai, however, was a leader in the broader anti-Balaka movement whose conduct and participation extended well beyond any single group of local elements. His conduct went towards the collective of anti-Balaka groups operating in the Western Central African Republic. As such, his physical distance from the commission of the crimes is not a mitigating factor for the purposes of sentencing. As his own words made clear, and I quoted them previously in French, les anti-Balaka n'ont pas deux entités. Les anti-Balaka que je coordonne sont un seul et même mouvement qui est réparti sur toute l'étendue du territoire. Quand je donne l'ordre à ces enfants, je pense que c'est immédiatement suivi des faits. That's CAR OTP 2122934. That doesn't require physical presence, and it is not decidedly peripheral or marginal involvement. The defendants contributed in different ways to the commission of the anti-Balakist crimes, with Yekatom as a principal and Mr. Ngai as an accessory. Both were senior members with authority and influence. Mr. Ngai acquired greater de jure authority in the group during the anti-Balakist commission of a number of charged crimes, and I emphasize during, including those crimes committed by Mr. Yekatom and his elements in January and February 2014, and those constituting continuing offenses, which began with the charged anti-Balaka attacks on the 5th of December at Bangui and Bosangoa. Essential components in the plan to reclaim power. I'll come to that. The recommended sentences are furthermore consistent with the appropriate treatment of convictions for multiple crimes provided for under Article 78.3. As I mentioned, 21 and 31 counts, respectively, between the two. Finally, the recommended sentences reflect the gravity of the crimes, given that they go to the heart of this court's function, duty, and of course, its express mandate. As the preamble provides, the court is established to address the most serious crimes of concern to the international community as a whole and must not go unpunished, and to guarantee lasting respect for and the enforcement of international justice. Before I come to the gravity of the crimes more fully, I'd first like to address the defendant's respective degree of participation and intent and other factors under Rule 145, 1C. The Chamber has the prosecution's submissions on the law regarding the modes of liability concerned in this case, and particularly the elements and application of Article 25(3)(c) and D. These are set out in our November 2020 trial brief in 3 separate applications for recharacterization of the modes of liability under Regulation 55(2) in May 2020, April 2022, and in July 2023. They are further set out in our application for reconsideration and alternative request to appeal the decision on the confirmation decisions filed in March 2020. Mr. Yekatom's participation in the charged crimes is clear and it is substantial. The modes of liability with which he is charged as a principal in committing those crimes and in ordering and instructing their commission are straightforward, legally and factually. His conduct precipitated the crimes against humanity and war crimes committed by his anti-Balaka group. The facts underpinning the elements of the modes of liability with which he is charged amply demonstrate Mr. Yekatom's substantial degree of participation and intent as regards the commission of the charged crimes. Although not aggravating as such, these facts are clearly important for the Chamber's determination of an appropriate sentence. In this case, we consider that they justify the imposition of the 22 years that are recommended. A finding of criminal responsibility under Article 25(3)(a) in this case presupposes that the Chamber has found the following predicate facts: that Mr. Yekatom actually committed the charged crimes as a co-perpetrator, that is, as a principal; that he agreed to a course of conduct with others which involved the commission of crimes under the statute, and that the charged crimes properly fell or fall within the scope of that agreement, whether tacit or express; that he made an essential contribution to the common plan, and that he acted with the requisite intent and knowledge regarding the perpetration of the charged crimes. In essence, in consideration of the sentence, the Chamber will necessarily have already determined culpability, and as such, that Mr. Yekatom knew exactly what he was doing, and that his contributions to the commission of the charged crimes at any stage, whether at conception, planning, preparation, attempt, or execution, were such that he had control over whether those crimes would be committed or the manner in which they would be committed. As an indirect perpetrator, the Chamber will have found that Mr. Yekatom committed the crimes through another or through his group, that he had control over the will of his group, that his group was hierarchically organized, and that the crimes were executed with near automatic compliance with his orders. Likewise, in finding Mr. Yekatom criminally responsible under Article 25(3)(b), for sentencing purposes, the Chamber will have already found that Mr. Yekatom was in a position of authority within his group, that he instructed others to act or to refrain from doing so as to commit a crime which occurred, or as regards its attempted commission, that his instruction had a direct effect on the crime's commission, and again, this is not limited to just its execution, both the subjective and objective elements, that he issued the order or instruction with the requisite intent and knowledge regarding the resultant crime. Mr. Yekatom's conviction of the charges thus entails that the Chamber would have found ample evidence of his substantial participation in the commission of the charged crimes, as well as a high degree of criminal intent and knowledge. Besides criminal responsibility arising from his participation in a common plan with the members of his command and his issuance of orders in the perpetration of crimes within its scope, the essential nature of Mr. Yekatom's contributions is also inherent to and derived from his position as the leader of his anti-Balaka group, a position which he enforced, a position which he never tempered, and a position that he exploited. You'll recall his 2016 interview outside the Socatel building in Baiki, not far from where Jido Saleh was brutally lynched and murdered in 2014, in which he describes himself as the leader of the anti-Balaka of the South. That's at Caro TP 211804415, not the so-called RFA-CPP that is referred to only recently by the defense in this case, but the anti-Balaka. It's a position in which he held out in several documents that he signed and issued, including this one. This is the document that he signed in respect of the demobilization of 153 children within his group. Yekatom relished his position as the ultimate authority in his group. It was a position he never relinquished for a moment during the charged events, and one that he asserted through different means, including violence. He held a position of responsibility in the conduct of his group, including their crimes. He cannot walk that back now, as his submissions clearly seem to try to do. Mr. Yekatom's leadership of his anti-Balaka group was not imposed on him. It was not an obligation, legal or moral or military. It was never a requirement. On the one hand, the defense argues that Mr. Yekatom had no military station during the charged period. On the other, they seek to minimize or excuse his involvement in the 5th December Bangui attack as merely following the orders of his military superior, Captain Charles Grémangu, an order he could have and indeed should have refused, knowing that his vengeful elements and commanders would commit retributive violence against the Muslim population. He had no military station. He was not bound to follow any order, but he chose to, and he did. His leadership over his criminal anti-Balaka group was his choice and his alone, as was his decision to lead his group in the attack of civilians. Mr. Yekatom's involvement in the commission of crimes of his group was likewise intentional. The evidence is that his choices were deliberate, and he made them in full knowledge that the elements and commanders who he accepted in his group and formed a part of it, including his military colleagues and commanders, were openly motivated to exact retributive revenge against Muslims. You saw the videos that we played during our closing submissions. Those are his men. His elements were true to their words and gestures in committing the charged crimes. They moreover did so over an extended period of time. Mr. Yekatom at the helm the entire time. His elements committed crimes well within the scope of violently targeting Muslim civilians. And his standing orders also reflected. Those orders included that the purpose of their training was, quote, so they could kill Muslims and Selikas because all Muslims were Selika, end quote. That's the testimony of P1339, transcript reference 152, page 10. Mr. Yekatom remained not only in command, which he exercised, but through his conduct, acts, and omissions, he clearly intentionally contributed directly to the perpetration of their crimes. The evidence of Mr. Yekatom's high degree of criminal participation and intent does not get clearer than the following. Mr. Yekatom and his commanders direct and express orders to kill Muslims and civilians. I'm sure you recall the testimony of P 1839 and P 1339. His acceptance of elements within his group who, without sanction or any fear of sanction, openly described driving Muslims from their homes and killing them, including babies. That one you have on video. His acceptance and tolerance of members of his group who tortured and beat abductees at the Yamwara school, and their murder of one, encouraged by his deputy. His acceptance and tolerance of elements who participated in the notorious and brutal lynching and murder of a Muslim public official in Mbaiki, Jido Saleh. His creation and perpetuation of a climate of impunity in his group in which the crimes committed by his elements were not merely inevitable, but encouraged. I refer you to paragraph 660 of our closing brief regarding the torture of Saint-Cyr, Lapo, and Goma, or paragraph 702 and following regarding his group's pervasive cleansing of the PK9 axis of its Muslim inhabitants, as an example. The list goes on. Mr. Yekatom's high degree of intent and participation is also shown by the evidence that proves the enumerated contributions set out in the confirmation decision, namely his structuring, training, and equipping of his anti-Balaka elements, his preparing of attacks and advances and leading his group in them, his issuing orders to anti-Balaka members, including patently illegal instructions. All of this conduct demonstrates a profound degree of participation and intent in respect of the numerous crimes for which he is responsible. This is moreover underscored by the fact that as a trained member of the FACA, Forces Armées Centrafricaines, which the defense acknowledges, Mr. Yekatom was versed on the basic tenets of international humanitarian law, which, among other things, forbids targeting civilians. Importantly, Mr. Yekatom's disregard of his fundamental training as a soldier underscores that his acts and conduct were deliberate, they were intended, they were purposeful, and his tolerance of members and commanders in his group who not unlike him, ordered that Muslim civilian men and women be killed was likewise in obvious contravention of his training. A training which should have seen him take action to protect the Muslim civilians in his zones of responsibility. He did the opposite. His defense seeks to argue that Mr. Yekatom's, quote, commitment to military values, end quote, at paragraph 16 of this submission, provides a framework for his conduct during the charged period in the Chamber's assessment of his individual circumstances. Your Honors, even a partially genuine commitment to FACA military values would not have seen the pervasive and violent crimes against civilians committed by his group and for which Mr. Yekatom is justifiably responsible. The defense's suggestion that Mr. Yekatom worked towards the promotion of peace, at paragraph 1 of their submission, is an affront to the innumerable victims of the crimes committed by his own anti-Balaka group under his leadership. In view of the facts provided in this case, it is an astonishing claim, one that stands common sense and logic on its head, and one roundly refuted by the overwhelming evidence introduced in this trial to the contrary, including testimony from several of his own elements. Indeed, in the commission of the charged crimes, there can be no question that Yekatom's conduct contributed to the immense victimization of and suffering inflicted on the Muslim community in his zones of responsibility. The suggestion that he promoted peace does not accord with reality. Even if it did, it in no way attenuates, much less negates, the extensive participation and intent that his conduct in respect of the crimes plainly demonstrates. Contrary to the defense's submissions, Mr. Yekatom's conduct during and after the relevant period only reinforces his reputation for extreme violence. Aside from the charged crimes, with the exception of recruitment of children under the age of 15. They were inherently violent. Yekatom also displayed a propensity for serious violence. He murdered two of his own elements, both members of the FACA, Oscar Seda and Vianney Kobola. His violence instilled such fear that his elements were even too afraid to report this to the police after the events. Yet he argues in his submissions that he has no convictions and a clean military record. The chamber heard the testimonies of P1339 and P1839, both significant insiders in this case, both of whom broke down before this chamber during the course of their testimony. P487 was candid about his complete fear of repercussions in testifying against this accused. I mentioned this previously. What you've seen of Mr. Yekatom sitting quietly in this courtroom throughout these proceedings is not the same Mr. Yekatom who was active in the field in 2013 and 2014. But you caught a glimpse of that person when he was arrested in the Central African Republic in 2018. His arrest occurred before the Central African authorities were even notified that a warrant for his arrest had been issued by this court. I'd like to show you what that duly elected, reconciliation advocating, peacemaking parliamentarian Alfred Yekatom looked like in late 2018 compared to now. I'm going to need a site translation for this video because the transcript is unavailable, but it is in French. So it should be well understood by the accused and pretty much everyone here.
Yeah, please play it.
That's it, play it.
Alors que l'un des favoris, Laurent Ngombaba, est en train de terminer son discours, des tirs retentissent et c'est le sauve qui peut.
C'est un moment de désolation. Vous savez très bien qu'on n'a pas le droit d'entrer une arme dans l'hémicycle national. Et nous avons vu aujourd'hui ce qui s'est passé. C'est vraiment déplorable.
L'auteur des coups de feu, c'est cet homme en survêtement appréhendé par les militaires. Alfred Yekatom, plus connu sous le surnom de Rombo, ancien milicien anti-Balaka, aujourd'hui député. Pourquoi a-t-il dégainé son arme et pourquoi a-t-il tiré? Ce député qui a été braqué ne le sait même pas lui-même.
Je me suis levé, j'allais vers lui en levant mes deux bras. Je lui ai dit, moi je n'ai pas de problème avec toi. Et c'est comme ça, il m'a laissé et il a continué pour que le forfait soit commis de l'autre côté.
Ce que l'on sait, c'est que Rombo était proche de Karim Mekassoua, l'ex-président de l'Assemblée nationale tout juste destitué. La destitution et ce coup de sang sont-ils liés? Une chose est sûre, le tout nouveau président de l'Assemblée nationale, élu à l'issue de l'incident, prend ses fonctions dans un climat plutôt tendu.
Effectivement, il y a eu des incidents très graves parce qu'il y a eu tentative d'assassinat. Il y a eu tentative d'assassinat et je crois nous sommes dans un pays de l'État.
Alors que l'un des favoris, Laurent Ngombaba, est en train de terminer son discours,
I think we have our translation in there. First of all, thank you very much to the interpreters.
No, indeed, that was very flexible, and we appreciate it. Thank you so much.
Your Honors, Mr. Yekatom's reputation for violence is well known, and it is well founded. It is now, and it was then. Even his first defense witness, D515, 5015, admitted reluctantly that he did not want Yekatom to come to Mbaiki for fear that he would make war. Mr. Yekatom's propensity for violence is a circumstance that the chamber not only should, but must consider in assessing the propriety of any sentence to be imposed. Moreover, it should consider the same in respect of the likelihood that the sentence imposed will be an effective deterrent, not only to others, but to Mr. Yekatom himself, to refrain from the type of violent conduct that has resulted in the marked crimes committed by him and his elements. Apart from the retributive targeting of Muslims pursuant to the common plan implemented by his group, Mr. Yekatom is also responsible for the recruitment of children under age 15. The Chamber has heard the testimonies of many witnesses, including P. 2476, P. 1974, P. 1839, P. 2018, P. 1813, P. 1716, among others, all of whom established Mr. Yekatom's substantial intent and participation in the recruitment of children under the age of 15 into his anti-Balaka group, either directly or inferentially. Notwithstanding the many allegations made by the defense concerning count 29, which we will not address in this context as they do not pertain to the question of sentencing, but whether Mr. Yekatom should be convicted in the first place. The fact is that harm was caused to these children by virtue of their recruitment into his armed militia, whatever the motive, whatever the purpose, and whatever the period. A violation of the statute does not require that the recruitment be for any given purpose or any period, and a violation of the statute warrants punishment. The statute's prohibition on the recruitment or use of children under age 15 in an armed group is normative. It prescribes the risk of harm inasmuch as it does an actual harm. Undoubtedly, the true extent of the harm suffered by such children may be latent, as might occur with psychological trauma or even community stigmatization. Conversely, the harm may be more immediate, such as might result from stripping the child of their otherwise protected status, which the Yekatom defense acknowledges, or the risk of harm may arise through exposing a child to potential attack while present at the base of the militia or elsewhere, such as at roadblocks, which the evidence clearly shows occurred in this case. You have the testimony and reports of experts in the fields who explain that these and other risks in respect of the recruitment of children into armed groups in CAR, including in the context of the anti-Balaka. Their expertise also addresses how children may be exploited in the context of their enlistment and recruitment, as well as how children involved in such groups may experience trauma, loss of schooling, social stigmatization, including within their own families. They may be faced with uncertainty about their future, particularly given that the networks of their former leaders often remain intact and active where they live. As you know, the expert reports particularly note the potential psychological impact of child recruitment, including from witnessing extreme violence and their own exposure to violence within the ranks of the group, whether through treatment as adults, the imposition of discipline, or active participation in violent acts. In that respect, I would refer you, for example, to paragraph 683 of our brief. Closing brief. The expert testimony and reports also explain projected longer-term effects from the lack of long-term support and individual follow-up, the persistence of indoctrination in their attitudes towards the former enemy of the group, as well as their continuing loyalty towards the group's principals, who retain influence over them and their families. Contrary to the defense's suggestion, the evidence is that Mr. Yekatom abused the power he held over his group within the meaning of Rule 145 2B2. The defense's argument that because he was no longer an indentured FACA member during the charged period, he could not have abused his authority or power on an official basis is specious at best. A military hierarchical relationship is not a prerequisite to demonstrating an abuse of power within the meaning of Rule 145. It is not even a prerequisite of issuing criminal orders. Rather, all that's required is that the chamber will have found...
Slow down a bit. Please slow down a bit. The interpreters would like to follow. And you know, English is always a bit quicker even than other languages.
Yes, thank you, Mr. President. All that is required, and the chamber will have found on conviction in accordance with the overwhelming evidence in this case, is that Yekatom held a position of authority within his group, which would compel the perpetrator's commission of the crimes on his order. You have that evidence amply in the record before you. The suggestion that Yekatom was not a FACA member after the Seleka's arrival is not relevant to his abuse of power in leading his anti-Balaka group, and it is, in any case, also contradicted by the evidence. You need only look at the footage from Mbaiki, in which he dons his uniform, fatigues, boots, beret, sidearm, insignia, and all, to see that that is exactly how he sought to portray himself and his commanders when it was convenient. Notwithstanding that, as the defense now concedes, he did not, quote, did not hold any official military title or role during the charge period, end quote. That's at paragraph 28 of their submission. Let me turn to Mr. Ngai ssona. Mr. Ngai ssona participated in the crimes as an accessory. He contributed to their commission with the intent and knowledge applicable to the modes of criminal responsibility under Articles 25(3)(c) and D. While the case against Mr. Ngai ssona was confirmed on this basis, the confirmation decision does not suggest that Mr. Ngai ssona did not participate in a common plan. Rather, the pretrial chamber's legal determination was that on the limited evidence before it at the preliminary stage of these proceedings, his contributions were not seen as essential. The defense's suggestion that Mr. Ngai ssona, quote, is not alleged to be part of a common plan, end quote, at paragraphs 9, 7, and 17 of their submission is in error. While his contributions do not lead to his responsibility for the crimes as a principal, that is, as one who committed them, to be sure, Mr. Ngai ssona is alleged to have agreed with others to engage in a course of conduct which entailed the targeting of Muslim civilians, a crime under the statute. In short, a common plan. And the evidence at trial amply demonstrates this, and thus goes to the degree of his criminal intent and participation, as well as his motive in respect of the anti-Balaka's crimes. That his contributions were not characterized as essential by the pretrial chamber in advance of the trial does not change the fact that the admissible evidence at trial showing Mr. Ngai ssona's knowing participation in a criminal plan is entirely relevant to the nature and extent of his involvement in the anti-Balaka's crimes and to any corresponding sentence. Mr. Ngai ssona's participation in the plan to reclaim power along with Bouzizi, Bernard Mokom, Maxime Mokom, and others, which entailed the commission of violent retributive crimes against Muslim civilians, goes to the degree of his participation and intent regarding the perpetration of such crimes in its implementation. Let me add, by the way, that the confirmation decision never addressed to any extent whether the crimes would have been committed in a significantly different way absent Mr. Ngai ssona's several contributions. That, however, is an entirely appropriate analysis of the evidence that this chamber may undertake in determining and fixing an appropriate sentence in view of the nature and extent of his participation in the commission of those crimes. That Mr. Ngai ssona's several contributions were not assessed under liability as a principle in no way constrains the chamber from holistically assessing their effect on the anti-Balaka's capacity to carry out the crimes, particularly in respect of their attacks on Bangui and Bosangoa and their aftermaths. As the pretrial chamber recognized, and the evidence is proved in this case beyond any doubt, these attacks were essential components of the strategy of Bouzizi's inner circle and supporters to reclaim That's at paragraph 111 of the confirmation decision. And the evidence in this case confirms this. Mr. Ngai ssona was indisputably part of Bozizé's inner circle. As Alfred Ngai, his eventual political advisor in the anti-Balaka coordination, pointed out, a person with whom he was in contact, by the way, in June already of 2013, throughout the charge period. What he said was, Ngai ssona was, quote, Ngai ssona was the right-hand man, one of the right-hand men of Bozizé, end quote. That's at CAR OTP 20930010, paragraph 62, his statement. He is one of many witnesses who attest to their close association. P 1847, P 2625, P 801, P 884, the list is extensive. As noted, our submissions regarding Mr. Ngai ssona, just like those concerning Mr. Yekatom, presuppose his conviction of the crimes with which he's charged and the Chamber's predicate findings in respect of the modes of liability underpinning those Article 25.3c and Article 25.3d. And although those facts, which underpin the basis of liability, are not aggravating in themselves, they are important to the Chamber's assessment of the degree of Mr. Ngai ssona's participation and intent, and his involvement in the crimes which we believe justify the 20-year term that we recommend. A finding of criminal responsibility under Article 25.3c in this case presupposes that the Chamber has found the following predicate facts. Mr. Ngai ssona assisted in the commission of the charged crimes, that he acted for the purpose of facilitating them, and that he had the requisite intent and knowledge pertinent to that of an accessory in the commission of those crimes. The Chamber would have found, as the evidence shows, that through his several contributions, Mr. Ngai ssona assisted in the commission of the charged crimes, whether practically, such as by facilitating the provision of the means for their commission, or by providing moral or psychological support, including through acts which encouraged their commission. Again, let me emphasize that the contribution to the commission of crimes must be understood to encompass any phase of the commission of crime, subjective and objective. Nothing in the statute suggests that it be restricted simply to the execution phase in the commission of a crime. Similarly, a finding of criminal responsibility under Article 25.3d in this case subsumes that the Chamber will have found the following predicate facts. Mr. Ngai ssona contributed to the commission of the crimes by the anti-Balaka, a group acting with a common purpose. That the anti-Balaka, that his contributions were made with the aim of furthering the criminal activity or purpose of the group, or in the knowledge of the group's intention to commit the crimes, and that he acted with the requisite intent and knowledge as an accessory regarding the perpetration of those crimes. In determining an appropriate sentence, the Chamber will have already satisfied itself of Mr. Ngai ssona's culpability, as such that he contributed to the commission of the charged crimes at any stage. The Chamber will have found that he did so with the aim of furthering the criminal activity or common purpose of the group. That is, he acted to promote the practical or ideological objectives of the group, or that he made his contributions to the group's commission of the charged crimes aware of its intent as a collective to commit them, consistent with Article 32. The evidence in this case establishes Ngai ssona's substantial participation in the anti-Balaka's commission of the charged crimes pursuant to this mode of liability. His contributions were pervasive, they were consistent, and they were continuing throughout the charged period. His intent to achieve his own and the group's objective to obtain power in the Central African Republic were unrelenting, and the evidence proves that he pursued them single-mindedly without regard to the human cost. In assessing the extent of Mr. Ngaisona's participation, the Chamber must not look to the nature of the contribution alone, but importantly, to its impact or effect on the commission of the crimes, whether it's subjective or objective elements. For instance, providing money or ammunition to facilitate a crime may assist in its commission insofar as these may comprise logistical support in its execution. But making money and ammunition available, even if they are not used, can also encourage the actor's impetus to commit the crime in the first place. A single type of contribution may affect the commission of a crime in different ways, but equally culpable, and thus bears directly on the extent of the accused's accessorial participation. As you know, a defendant's assistance in the commission of a crime need not have an effect on its execution. As such, it suffices that the contribution affected any phase of its commission. There is no reason why, for instance, contributing to the implementation of a criminal policy is any less serious than contributing to the physical execution of the crimes committed pursuant to that policy. In convicting Mr. Ngaisona as an accessory, the Chamber would have found that he contributed to the commission of the Anti-Balaka's crimes for the purpose of facilitating their commission, and/or that he did so with the aim of furthering the criminal activity of the group, or in the knowledge of the group's intention to commit the crimes. These are significant factual predicates that necessarily go to the nature and extent of Mr. Ngaisona's involvement, and the Chamber's determination of an appropriate sentence corresponding to the gravity of his individual conduct in respect of these very serious crimes. The crimes are of a nature such that contributing to their commission to any extent, let alone doing so for the purpose of facilitating them, or aware that the perpetrator group intended to commit them, or to further the criminal activities of that group, is extremely serious, and it reflects a high degree of criminal participation and intent. As you know, in the Charles Taylor case before the Special Court of Sierra Leone, Mr. Taylor was found guilty of aiding and abetting the Revolutionary United Front, the RUF, in all 11 charges that he faced, which included murder, rape, and pillage. Mr. Taylor asserted, among other things, that he was a peacemaker. Imagine. The Chamber rejected that evidence, finding that while he publicly supported the peace process, he privately undermined the negotiations supporting the RUF through financial, operational, and moral support. He was thus found responsible for aiding and abetting their activities as well as planning attacks. As an accessory, although he was convicted, he was sentenced to 50 years, which was affirmed on appeal. And notably, that appeals chamber found error in the trial chamber's statement that aiding and abetting as a mode of liability generally warrants a lesser sentence than that to be imposed for more direct forms of participation. That's at that appeals judgment. I can give you the reference anyway. It's at paragraph 666, SCSL 0301-A. That appeals chamber found that the totality principle, which applied in that court's framework, which is similar to that enshrined under our Article 78 and Rule 145 was that the sentence must reflect the gravity of the accused's actual conduct, and that a hierarchy of gravity among the forms of criminal participation is contrary to the essential requirement of individualization. This Court's appeals chamber similarly recognized, and I quote, "The Court's legal framework does not indicate an automatic correlation between the person's form of responsibility for the crime or offense for which he or she has been convicted and the sentence, nor does it provide any form of mandatory mitigation in case of conviction as an accessory to a crime or offense." That is the Bemba Appeals Judgment, number 2276 at paragraph 60. Yet the contrary is implicitly advanced in Mr. Ngaisona's written submissions, notably at paragraphs 8 through 10, 12 through 13, in which they argue that he had no direct involvement, his acts were of marginal significance, or his contributions peripheral. As the evidence has proved in this case, Mr. Ngaisona's culpable conduct in this respect far predated the 5 December 2013 anti-Balaka attacks on Bangui and Bosangoa. It extended back to the origins of the engagement of the anti-Balaka by Mr. Bozizé and his inner circle in this conflict, long before. In this respect, I refer you to our closing submissions on his individual criminal responsibility in particular, as well as our trial brief at paragraph 660 and following, and also our closing brief, which spells this out. As we submitted, the evidence shows that Mr. Ngaisona had a choice whether or not to involve himself with Bozizé's hate speech and disinformation. He had a choice whether to involve himself in Mr. Bozizé's plan to return to the so-called constitutional order through means that were inherently criminal. He had a choice whether or not to involve himself in galvanizing and coordinating the affairs to that effect. He had a choice whether to withdraw or renounce his involvement with the group. At each instance, he chose to be a leader in the group. He chose to assist, to contribute, to coordinate, to instruct, to fund, to liaise, to encourage, and to lend support, moral and practical. Mr. Ngaisona did this despite the fact that the Muslim civilians in his country would be and were being indiscriminately and unapologetically targeted in Western CAR by the group that he helped to coordinate and ultimately came to lead, while his crimes were ongoing or continued to be perpetrated no less. Contrary to the defense's arguments in their submissions of paragraph 13, Mr. Ngaisona's contributions to the anti-Balaka were not of marginal significance. Had they been, he would not have found himself at the helm of the group throughout the charge period. The evidence is that he was a recognized leader, one of great influence and efficacy in consistently promoting the interests and objectives of the group, whether politically or operationally. He was directly involved in the anti-Balaka operations and in contact with the group's military leaders and comm zones. Mr. Ngaisona's role in respect of the formation of the anti-Balaka was key. The evidence establishes his abiding intention to achieve the political ends for which he, along with Bernard Mokom, Maxime Mokom, Bozizé, and others within Bozizé's circle, sought to instrumentalize the anti-Balaka elements, fully aware of their intention to exact violent retribution against Muslims, who they held collectively responsible for the Seleka and the Seleka's crimes. There can be no doubt about that. The evidence shows that Mr. Ngaisona sought to advance the practical and ideological objectives of the anti-Balaka. The chamber has before it the testimony of several witnesses who substantiate his involvement in the formation of the group and in its operations thereafter, including in respect of attacks carried out not only as charged, but other anti-Balaka attacks committed in Western CAR within the same context of the group's Article 7 attack between 2013 and 2014. Boire is one such example, and I refer you to our closing brief at paragraphs 111, 131, 153, and following. He engaged with Comzone's Achid Godinam, with Amadou Ndale, and helped to recruit and coordinate elements to support the October 2013 Boire attack, the Archers, led by Ndale. As P2841 noted, quote, Bernard Mokom and Ngai ssona were starting to organize the anti-Balaka and also the military, but at that point it was a matter of wait and see. That's at Caro TP 2127-4238 at page 4258, paragraph 117. He continued, quote, Ngai ssona undertook to go to the border personally to take charge and push things forward. Same statement, paragraph 110. P2763 explained that, quote, Ngai ssona wanted to be a leader. The goal of Ngai ssona's group was also to take power. Caro TP 2127-6435, Paris, and there's several paragraphs, 132, 153, 155, and so on. You have the statement. As you know, the Boire attack resulted in the deaths of some 20 civilians, but also the displacement of about 10,000 people. And it followed the attacks on Bosangoa between 6 and 9 and on 17 September 2013. Here you see Ngai ssona responding to Mr. Ngaya, confirming that there are men on the ground maneuvering and asking what he can do, that is Ngaya, to accentuate the degradation of the situation in Bangui and elsewhere. Beyond this, you have CDR evidence, which reflects his contacts with the Goberi chiefs, including Dedan, and his provision of money to the Goberi group, and to Godinam's elements to fight in Bosangoa. You have the testimony of several insider witnesses to the same effect. His involvement was not peripheral or marginal. Beloko is another example, on the 20th of January 2014. And I refer you again to our closing brief at paragraph 266. You have the testimony of P1719 in that respect. You also have the evidence of P1847, who said, and I quote in French, Le Comzone de Boire, à savoir Ndale, a confirmé cette attaque de Beloko et il avait ajouté que lui-même s'apprêtait à attaquer Boire, qui était une base de la CDK, suivant des instructions de Bernard Mokom et de Ngai ssona, notamment suite à leur rencontre de Yaoundé, end quote. That's at Caro TP 2061-1534, paragraph 142. There's really not much doubt about Mr. Ngai ssona's substantial participation, not only in the formation of the anti-Balaka, that is, in respect of their galvanization, their instrumentalization, in order to carry out the plan of Bozizé and his inner circle, but also his involvement in the operations of the group. What the evidence proves is not someone who was remote, contrary to the defense paragraphs 8 and 19, but instead a person who was active and involved, and substantially so. Again, take a look at this one. This is an email from 7 October 2013. You've seen it before, in which Mr. Ngai is seized with a request to facilitate the purchase of weapons, carton. And you can see the locations. Take a look at this next one from the 12th of October, 2013. Besoin, Zone Sud. Same thing, same story. Take a look at this next one. This is Mr. Ngai transmitting these requests to Eric Danboy. Bozizé's close protection, Lieutenant. When we closed in December, I posed the question, why would Ngai be involved with this? The football chief. I expected to see a plausible response in the defense submissions. So I looked for it, and there wasn't one. Your Honors, this is not what a person having only a peripheral or marginal role in a militia does, contrary to the defense submissions. It is what a coordinator does. This is how a coordinator participates. You have that evidence before you. P2483 testified, and I quote, everybody knew that Mr. Ngai was the coordinator of the Anti-Balaka. That was already in October 2013. P884 testified, quote, everybody knew that they, that is Ngai, Bernard Mokom, and others, were in Cameroon and that they were setting up a resistance structure. P2841 testified, quote, as the Anti-Balaka advanced on the ground and were taking over a number of cities, it was understood that he, Ngai, would be the one in charge of resources, mobilizing resources, and that resources should be transferred through him, end quote. P1847's evidence is, and I'll quote it in French, parfois aussi Ngai et Bernard Mokom effectuaient des transferts d'argent aux Anti-Balaka en RCA via Express Union. He adds, Ngai, quant à lui, utilisait beaucoup son frère cadet pour faire des transferts de fonds à destination de Garamboulaye et aussi à Bangui. That's at paragraph 16, CAR OTP 2061-1534. He continues, quote, Ngai a donné de l'argent à Mokom Père ou à Fred Serefio, qui à leur tour les transmettait aux troupes anti-Balaka. CAR OTP 2122-8251 at paragraph 115. He also said, quote, Ngai contrôlait et vérifiait si l'argent qu'il a transféré aux combattants était bien arrivé à leur destination et avait été utilisé aux fins projetées. Par exemple, l'achat des munitions. That's at CAR OTP 2061-1534, paragraph 112. And finally, quote, Ngai a donné expressément des ordres et des plans d'attaque aux autres anti-Balaka qui restent sur le terrain en RCA, et cela par voie téléphonique, end quote. And that's also paragraph 112. Take a look at this document. I also showed you that before. This is a document that was attached to an email sent to Mr. Ngai by the so-called Franklin. As you can see, the document concerns military needs, as the email describes. This is Ngai Sona's response. Add les articles de chasse and financial requirements for the anti-Balaka. This is in January. This is before he comes back from Cameroon. On the evidence you have before you, it is clear that les articles de chasse for the anti-Balaka means ammunition. For the improvised and artisanal weapons, the ones that you know and the evidence shows were used to carry out crimes and attacks in Western CAR. The only thing that explains this is Ngai Sona's substantial participation in the events, which include the Anti-Balaka's commission of crimes during the course of its extensive Article 7 attack on Muslims in the Western Central African Republic. Proof of his substantial participation and intent do not require that his contributions to the logistical and organizational capacity of the group be such that without them, the group could not carry out the attacks or the resultant crimes. They do not require that his assistance or support be used in the 5th December attacks and the aftermath, which is what I was describing before, in terms of the effect of the contributions. It does not require that his assistance, quote, gave the anti-Balaka movement a military advantage or influenced the decision to conduct the 5th December attacks, as put forward in the defense submissions at paragraph 13. And Ngai Sona's extensive involvement with and support for the anti-Balaka is amply demonstrated in this case. And it was moreover done in the knowledge that the crimes that the group's elements would commit them, they were committing them, they had committed them, and they would continue to commit serious crimes. The evidence demonstrates a profound degree of his criminal participation and intent, albeit as an accessory to the group's violent crimes relentlessly perpetrated against Muslim civilians in the western part of the country. Ngai Sona's high degree of intent and participation is also shown by the evidence proving his enumerated contributions as set out in the confirmation decision, namely taking steps to structure the anti-Balaka, financing the anti-Balaka including for the purchase of weapons, issuing instructions to anti-Balaka members including with regard to the 5th December attack and attacks preceding it, and liaising with anti-Balaka members exercising key functions, including Bernard Mokom and Maxime Mokom. As his sentencing presupposes Ngai Sona's conviction of the substantial crimes charged, the 5th December attacks on Bangui and Bosangoa, and those committed in their aftermaths, it is notable that his participation extends to the planning and execution of the 5th December attacks in implementing the plan to retake power, including the intermediate steps taken by the group to achieve that aim. Thus, although an accessory, Mr. Ngai Sona's support of the group involved operations lending to those seminal attacks. The group's advancement and engagement of the Seleka en route while committing serious crimes along the way. The Ngai Sona defense argues that Mr. Ngai Sona did not, quote, did not possess direct intent for any of the crimes charged, end quote, paragraph 17 of their submission. First, the evidence at trial completely refutes this. And in any case, it doesn't really matter when you consider not only the totality of the gravity of his conduct and contributions, but their effect on the continuation of the anti-Balaka's commission of crimes pursuant to the group's organizational policy. A policy which the evidence shows Mr. Ngai Sona had a hand in fostering and perpetuating along with other members of Bozizé's inner circle. You saw the anti-Balaka's criminal policy at work, as expressed by elements themselves during the trial and in our closing statement. It's on video. It's in print. And there's ample evidence of Ngai Sona's full awareness of the animus which pervaded the group of which he was a part. An animus, as the evidence shows, he took part in fanning through speeches in support for Bozizé's inflammatory rhetoric, through his involvement in Froka and the rhetoric disseminated by that group, and of course through directly liaising with anti-Balaka leaders and comm zones on the ground, both in 2013 and in 2014. The suggestion that Mr. Ngai Sona did not intend that Muslim civilians be subject to the retributive violence of the anti-Balaka does not in any way diminish the fact that, with knowledge that they would inevitably be targeted, he persisted in supporting the known authors of their demise in Western CAR and the destruction of their communities. He participated objectively and subjectively for the duration of the charge period. He did so when he was in a position of influence and authority, not only to desist himself, but to impede the anti-Balaka's commission of serious crimes with which he now properly stands charged. Article 32 defines intent within the meaning of the statute. Provides that a person has intent in relation to a consequence when they are aware that it will occur in the ordinary course of events. And Ngai Sona had intent within the meaning of this article, at the least. He knew certainly that the crimes, that the anti-Balaka were animated by pure vengeance against Muslims, and those crimes were certain to occur. He knew that as certainly as everyone around him knew. As Ngai explained, once again in his statement, quote, Muslims had to be blamed for the Seleka's conduct, as they protected the Seleka. That is why Muslims, and not just the Seleka, became the target of the anti-Balaka. Caro TP 20930010, paragraph 37. He added at paragraph 40, quote, on 5 December, the anti-Balaka killed many innocent Muslim civilians, women and children. I think that they targeted Muslim civilians because when the Seleka arrived, they were friends with the Muslims, and they attacked non-Muslims. Therefore, people felt hostile towards Muslims. P 1847 acknowledged, and this is at his statement, Caro TP 2061-1534, paragraph 161, and I quote in French, Il faut dire que les anti-Balaka commettaient beaucoup d'exactions sur les populations musulmanes au cours de leur progression. Au niveau de la hiérarchie des anti-Balaka, il n'y avait aucune sanction qui découlait de ces actes criminels. No sanctions within the group before Ngai Sona was designated general coordinator, and certainly none thereafter. You have much more at your disposal. Suffice it to say that Ngai Sona's participation in the anti-Balaka and his promotion of its aims and objectives, practically and subjectively, are clear, and they are markedly substantial. It is no accident that contemporaneous exchanges among the group's supporters and people close to Bozizé and his inner circle describe his involvement particularly. This is a 3 September 2013 Facebook exchange, and I've cut it down just so that you can see the reference to Mr. Ngai Sona. Here, he's mobilizing the archers. He's named specifically. In this next one, 14 October 2013, he's providing ammunition, medication to the archers. And he's named in this document. In the next one, 23rd October 2013, he's providing ammunition and Toraya. In this next one, he's sending men to the border. PGs or GPs, garde présidentielle, et les Gbaya, firstly. In this next one, 27 November 2013, Ngai ssona is managing the anti-Balaka. Il gère les anti-Balaka. In this next one, 1 December 2013, Ngai ssona is providing money to deploy elements. The suggestion Ngai ssona lacked intent with regard to the commission of the crimes or was peripherally involved in this case is not plausible. His intent within the meaning of Article 32 was substantial and it was pervasive. Mr. President, I have a ways to go, not a reasonable amount to go, but I don't know if you're willing to take a break at the moment.
Have you already, do you think you have a natural break now? Otherwise, you could continue a couple of minutes and we could, let's have the break, for example, until 11:45. I would leave it to you, actually.
I can go a couple of minutes, I think.
Yes, so we do it this way.
Thank you.
Yeah. Perhaps a couple of minutes after 11 and then we adjust the break. Thank you.
Mr. President. I was just moving now to come to the gravity of the crime, so I think I can cover that in just a few minutes. As I mentioned, the crimes involved in this case are inherently grave. As we noted, the forcible transfer, deportation, and displacement of thousands of Muslim civilians severed them from their homes, from each other, from their communities, and indeed parts of the entire country. In a word, they lost everything. Many were condemned to live out years of their lives in IDP camps under constant threat by the anti-Balaka, or refugee camps in neighboring countries to which they had no substantial connection. Collectively, the Muslim population was subjected to acts of violence and persecution on account of nothing more than a shared religion with the majority of Seleka members, if that. For the anti-Balaka, a Muslim having tea with a Seleka member might be considered enough justification to be killed. The violent crimes which comprise the charges in this case, particularly as against persons rather than property, have taken an immeasurable toll on their victims, one which can never be compensated for. The killings, torture, rape, and the sheer number of victims effectively decimating the Muslim population in Western CAR attest to the gravity of the anti-Balaka's widespread attack and the many crimes which comprised this campaign. The charged crimes to which the defendants contributed were a substantial part of that. The Chamber may and should consider the expert evidence before it, including from the Stanford Human Rights Trauma and Mental Health Program, which explains how extensive the impact of these types of crimes may be. And in particular in this case, particularly forcible transfer, displacement, rape, sexual violence. That evidence explains, among other things, how trauma experienced by the victims of such devastating crimes may be transmitted even intergenerationally. It explains the psychological outcomes for victims of violent crimes, displacement, sexual violence, rape. It also explains the impact of crimes regarding the destruction of culturally significant property and religious sites, and not just buildings. They note that this is often overlooked in assessing trauma. Although the deliberate destruction of important social, cultural, infrastructure, and symbols has profound psychological effects. By contrast, its impact isn't overlooked by the perpetrators of such crimes and has long been used as a tactic in conflict. Suffice it to say that there is no plausible argument to be made that the defense can make or that anyone can make which diminishes the severity and gravity of the crimes committed by the anti-Balaka in the context of this case, and in particularly in respect of the crimes to which the defendants contributed to the commission of. Mr. Yekatom's assertion, for example, that the return of some Muslims to Mbaiki in 2015 and 2016 somehow reduces the gravity of the crimes charged under counts 4, 5, 24, and 25 in relation to the returning victims fails to appreciate the impact of the nature of such crimes and, of course, the scope of Mr. Yekatom's participation in them. The same goes for the assertion that the release of the Lapo family members amounted to a single evening, as somehow suggesting a diminution of the suffering that they endured. They went home, but they also went home without a family member, who, according to this evidence, was peeled like a papaya. The evidence, as you recall, is that before the intervention of others, including members of the anti-Balaka, Mr. Yekatom would have had those people that were released killed. That's the evidence you have. And you also recall, no doubt, the moving testimony of one particular witness, P967, who after all these years pleaded from that chair to know where Saint-Cyr Lapo's body could be found. I'm sure that that testimony haunts us all. She said, and I quote, "Je le redis encore, si le commandant des anti-Balaka, les responsables des anti-Balaka qui a tué Saint-Cyr Lapo, s'il a été enterré, je lui supplie de m'indiquer où se trouve la tombe." Transcript 200, page 11. The defendant's submission, both of them, wholly fail to acknowledge and to appreciate the depth of the harm and the suffering that their actions have contributed to. It is immense and it is profound. Now is a good time for the break, Mr. President.
Okay, then let's have the break until, as I already indicated, 11:45.
All rise, veuillez vous lever.